Okay, welcome to our channel. Once again, if you're new to the channel, remember to subscribe to our channel, add your comments and contributions, share this video. We're basically working more on human rights issues in Africa. That if you're interested in human rights, you can always contact us. We will have some details in the description area. And so if you need any sort of human rights a lecture or coaching, you can always contact us. At the moment, we are dealing with Rwanda. If indeed Rwanda is a safe country, this is the second part following on from our previous video, which talked about Rwanda's withdrawal of optional declaration 34.6. Which is an optional declaration for individuals and also for NGOs with observer status with the African Commission to access directly the African Court on Human and People's Rights. The issue why civil society and human rights organizations have basically pushed for this optional declaration 34.6 for individuals and NGOs to directly access the African Court has been the fact that since the establishment of the African Court in 1998 in Ouagadougou in Burkina Faso, establishing its head office in Arusha in Tanzania, the African Commission, which was established in 1987, has only referred 3 cases to the African Court on Human and People's Rights. There is that concern that there is that widespread human rights violation in Africa. To name but a few cases is the case of Burkina investigative journalist Norbert Zongo in 1998 in Ouagadougou. He was killed by the Burkina Presidential Guard. And obviously his case was not basically given adequate domestic coverage or domestic reparation or restitution. And so the case came to the African Court on Human and People's Rights, who then ruled in favor of the applicant and basically instructed the state of Burkina to actually pay the family reparation. Then we also have the case of Victoria Ingabire Omhoza of Rwanda, who was also imprisoned unlawfully by the Rwandan administration. She was once again released from prison under presidential pardon in 2018. However, she has not been allowed to travel out of Rwanda to see her family, and she has not seen her family since 2010. Her family that are currently resident in the Netherlands. And there was some sort of an article written by Ingabire Victoria Omhoza detailing these facts. We also have the case of Ken Saro-Wiwa, basically an Ogoni man who fought to defend the Ogoni land from environmental degradation and also the displacement of the indigenous people of Ogoni, Nigeria. So he was actually hanged. He was basically imprisoned and hanged in 1995 by the then military government. I think would have been Abacha, head of state Abacha, his administration, in collaboration with Royal Dutch Shell. So they were the ones that were basically drilling oil in Nigeria and has caused a great deal of environmental devastation to the land of Ogoni. And obviously with all the monies that they have made in taking this oil from the land, the people of Ogoni were not basically given any sort of reparation or compensation. Their land has been destroyed. And when Ken Saro-Wiwa basically mount the campaign, he was paid back by an arrest, an unlawful detention, and eventually he was hanged. So even though Ken Saro-Wiwa's case predates the African Court on Human and People's Rights, at the time of his case in 1995, the African Charter had been established in 1986, and also the Commission, the African Commission, had been established in 1987, and therefore such injustice shouldn't have been allowed to prevail. And so this is why we kind of push on with this African human rights issues, and also to look at why Rwanda withdrew their optional declaration 34.6. The reason why Rwanda is also a topic here is the fact that in October 2023, the UK Supreme Court ruled that the UK couldn't send UK refugees to Rwanda on the basis that Rwanda was not a safe country. However, once again, the then PM Rishi Sunak basically overruled the Supreme Court through the use of the parliamentary supremacy to make the Rwandan bill a law. But as we know now, that law has been scrapped by now Prime Minister Keir Starmer. So we carry on from the previous video. The withdrawal. The first of these cases, Ingeberi Victoria Mhoza versus Rwanda, was scheduled for hearing by the court on 4th March 2016. A few days before that date, on 24th February 2016, the government of Rwanda sent a note verbal officially withdrawing the declaration to AU Commission and African Court. The text of the note verbal reads as follows. Withdrawal for review by the Republic of Rwanda from the declaration made under Article 34.6 of the Protocol for the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights. Whereas on the 5th day of May 2003, Rwanda, in exercise of its sovereign prerogative, ratified the protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, thereafter referred to as the protocol. Let's go down. Whereas Article 5.3 of the protocol stipulated that the court may entitle relevant non-governmental organizations with observer status before the commission and individuals to institute cases directly before it in accordance with Article 34.6 of this protocol. Whereas Article 34.6 of the above mentioned protocol stipulated that at the time of the ratification of the protocol or any time thereafter, the state shall make the declaration accepting the competence of the court to receive cases under Article 5.3 of the protocol, and the court shall not receive any petition under Article 5.3 involving a state party which has not made such a declaration. On 22nd day of January 2013, the Republic of Rwanda unilaterally made the above mentioned declaration. Considering the 1994 genocide against the Tutsis was the most heinous crime since the Holocaust, and Africa and the world lost 1 million people in 100 days. So this is brutal. To lose 800,000 people in less than 100 days. And so the optional declaration, as I mentioned earlier, was actually inspired or influenced by the genocide in Rwanda. Because the genocide occurred in 1994 and the African Court was established in 1998. Considering that a genocide convict who is a fugitive from justice has, pursuant to the above mentioned declaration, secure a right to be heard by the Honorable Court, ultimately gaining a platform for reinvention and sanitization in the guise of defending the human rights of the Rwandan citizen. Considering that the Republic of Rwanda, in making the 22nd January 2013 declaration, never envisaged that the kind of person described above shall ever seek and be granted a platform on the basis of the said declaration. So I'm going to pause here and basically talk a little bit about this. And so this is the case of General Kuyamba Nyamwaza and others that involve Safari Stanley, and their case number 016-2015. So these guys were regarded by the Rwandan government as not having local standing to actually present their case to the African Court on Human and People's Rights. Albeit, when the verdict, the final verdict of the African Court on Human and People's Rights basically rejected their application. But the argument here that caused Rwanda to withdraw their optional declaration 34.6 was purely the fact that these individuals had actually escaped justice, or yes, basically escaped justice in Rwanda, and so they were regarded as genocide fugitives, which means that the African courts in the first place shouldn't have allowed them to actually present their case to the court. The complication of such is the fact that in the same application, under paragraph 7, Safari Stanley made an affidavit claiming that President Paul Kagame had basically influenced the judicial decision of Rwanda. And so if you look at it from that perspective, then the African Court on Human and People's Rights actually did have the right to actually allow these individuals to present their case to the court, because the fact is that there wasn't judicial independence based on the affidavits. Even though the affidavits is not proven, there wasn't that judicial independence in Rwanda. And so the court is actually established for such people to have the opportunity to present their case. And so potentially that in itself, if substantiated, shouldn't be the reason why Rwanda should actually withdraw their mandate 34.6. In reality, the reason why the case, obviously the General Kuyamba Nyamwaza, these names are a little bit difficult to pronounce, and Safari Stanley's case was rejected by the African Court, was basically on the fact that they were basically requesting that the Article 101, the constitutional amendment of Rwanda, through a referendum, which then allowed President Kagame to run for more than 2 terms. They felt that that was illegal and it shouldn't be allowed or should be blocked. So this was rejected on the basis that the referendum of Article 101 amendment was actually done through a referendum and was voted by the electorate of Rwanda, and therefore couldn't necessarily be deemed as an illegal act of him extending his power. Another way to also argue it is the fact that by President Kagame running for more than 2 terms, or obviously in his 3rd term, it did not necessarily restrict these other parties to actually to participate in those elections. So this is how you can actually argue this. But the real challenge actually lies in the practicality. The practicality of, can you really go in there to participate and be safe? So these were some of the questions that needed to be answered in this case. Considering that the Republic of Rwanda is making the 22nd January 2013 declaration, never envisaged that the kind of persons described above will ever seek and be granted a platform on the basis of the said declaration. Considering that Rwanda has set up strong legal and judicial institutions entrusted with and capable of resolving any injustice and human rights issues. So this one is basically the state against the applicants, because Safari Stanley had also made an affidavit in paragraph 7 of application 016-2015 that the president was actually influencing judicial independence in Rwanda. So that was also relevant in trying to find out who is really telling the truth. Now, therefore, the Republic of Rwanda is in exercise of its sovereign prerogative, withdraws the declaration it made on the 22nd day of January 2013, accepting the jurisdiction of the African Court on Human and People's Rights to receive cases under Article 5.3 of the protocol, and shall make it afresh after the comprehensive review. This is also a contestable or a contentious issue on the basis of the withdrawal came in just before the case of Omhoza Ngabere Victoria came to trial, because her case, she had actually stayed in Rwanda. She had been in prison under two different laws for the same issue, and she had been sentenced on one account 8 years and on the other account 15 years, and she had subjected herself to the laws and to the judiciary system of Rwanda. And so when her case came to the African Court, it was only obvious that she was basically treated as a political opponent or a political dissident, and her human rights were being abused. And so in order not for Rwanda to actually face the African Court and lose that case, they quickly then withdrew their Article 34.6. But then the problem here is that as they withdrew their Article 34.6, the African Court on Human and People's Rights did not necessarily, probably never envisaged that a country was going to withdraw their mandate. And so they didn't have anything, a mechanism in place for withdrawal processes or procedure. So what they then, the African Court on Human and People's Rights had to resort to is that they then resorted to the Vienna Convention on the Law of Treaty, 1969. Article, I am just out of on top of my head, I will say Article 56.2 is what they refer to as a way of managing Rwanda's withdrawal. But what this VCLT? Yeah, VCLT 1969, Vienna Convention on the Law of Treaties, allows under its Article 56.2 was the fact that if such thing happened, then there was that period of 12 months of which existing cases was basically valid for the African Court to trial, and also any cases that came within that 12 months, where so it's like a withdrawal notice. They have to refer to the Vienna Convention on the Law of Treaties 1969, because this Vienna Convention on the Law of Treaties 1969 is the convention that governs all treaties. So in its Article 56.2, which I really think that is, I could refer to it, but I think it's 56.2, actually says that the withdrawal notice should be 1 year. And within 1 year, any cases that were brought against Rwanda to the African Court on Human and People's Rights were valid cases. And the existing cases could also be tried by the African Court on Human and People's Rights. What we then noticed was that the Rwandan government had actually stopped their communication with the African Court after their withdrawal statement. It is also known that even the case of Ingabire Victoria Omhoza, when the reparations order was issued against the state of Rwanda, it appears that as at 2024, so this was issued in 2018, as at 2024, the Rwandan government had not settled the reparation. And so they are not taken to the African Court. They are not responding. In a way, they are also not respecting the Vienna Convention on the Law of Treaties of 1969. The Rwandan government's action is not respecting that either, which is an international treaty. But indeed, they should be respecting that. Because if they've withdrawn their Mandate 34.6, they are obliged to actually see through the end of all existing cases and also honor those existing cases in as much as cases that were brought up to the court up until the end of that notice period. And so that in effect is a sense of a failure on the part of Rwanda. And so then it questions Rwanda being a safe place, because if Rwanda does not respect or honor their own signatory or optional declaration to the African Court on Human and People's Rights, and also dishonors the Vienna Convention on the Law of Treaties in as at 1969, which actually it's Article 56.2, which gives the direction for withdrawal notice from a treaty, then that means that Rwanda indeed may not necessarily be a safe place where an individual could seek judicial remedy. So we carry on. Done at Kigali this 24th day of February 2016. In this context, the government of Rwanda did not appear for the hearing of the case. The case did not entertain any argument, but rescheduled the case for its session in May. The exception is that after an exchange of pleading during the intercession, the question of the legal validity and potential consequences of the withdrawal and of the merits of the case, it came to that. If it comes to that, will be determined at the next session. Applicable law. There is no provision in the African Court Protocol regulating the withdrawal from either the protocol or of the Declaration Article 34.6. In the absence of any specific prescription in the treaty, the general rule is that in the treaty, the general rule is that the general rule in treaty interpretation as set out in the Vienna Convention on the Law of Treaties, VCLT, applied. Rwanda acceded to the Vienna Convention on the Law of Treaty in 1980. So this is an international treaty that governs all treaties. So it is called the Treaty of Treaties, the Vienna Convention on the Law of Treaties in 1969, which obviously it appears that Rwanda had signed up to in 1980. So potentially they were obliged to respond to the directions or the directives of the African Court and also the Vienna Convention on the Law of Treaties. And I think that it is Article 56.2, so we can see it here. The Vienna Convention of the Law of Treaty in Article 56 sets out the following denunciation of or withdrawal from a treaty containing no provision regarding termination, denunciation, or withdrawal. A treaty which contains no provision regarding its termination and which does not provide for denunciation or withdrawal is not subjected to denunciation or withdrawal unless 1. Or A, it is established that the parties intended to admit the possibility of denunciation or withdrawal, or B, a right of denunciation or withdrawal may be implied by the nature of the treaty. A party shall give not less than 12 months' notice of its intention to denunciation or withdrawal from a treaty under paragraph 1. So this is the one that I was talking about, Article 56.2, which gives the period for notification as 12 months. Questions arising. Does the Rwandese government note verbal constitute a withdrawal? Some uncertainty was expressed about the meaning of the withdrawal issued by Rwanda. Uncertainty arose due to the insertion of the phrase "and shall make it afresh" after a comprehensive review. Some participants felt it is at best a purported withdrawal. It was also suggested that was a conditional or suspended withdrawal. Most participants, however, seemed to agree that as a unilateral statement undoing a voluntary act, it was a withdrawal plain and simple. These writings are very faint, so is the withdrawal legal / allowed for? There seemed to be a consensus that the withdrawal is most likely valid on the basis that a unilateral acceptance can lead to a valid revocation in line with the consensual basis of international human rights law and treaty law. Withdrawal from a declaration is also different from withdrawal from a treaty, where withdrawal from African Charter and the African Court Protocol will be very difficult depending on the justification under international law. The position in respect of a withdrawal under Article 34(6) is distinguishably from withdrawal from a treaty. And so this one is talking about the way you treat a treaty and an optional declaration. And so Rwanda is playing smart by not necessarily saying that they are withdrawing from the African Charter or the Article 1 of the founding protocol, but they were just withdrawing from the optional declaration. So this optional declaration was an additional submission or deposit of which the Rwandan government actually gave to the court at their own will, and therefore also had the right to withdraw this mandate. Once again, they can withdraw at will. And considering that the African Court on Human and People's Rights did not make any specification, i.e. in relations to what it meant or what the cost would have been, then you could only refer to the Vienna Convention on the Law of Treaty, referring to its Article 56(2), which made the withdrawal notice a 12 months notice. So we carry on. Where are the implications of the withdrawal? Most participants agree that its effect is not retroactive or retrospective. Even if the withdrawal is valid, it does not affect cases that have already been submitted. The court will therefore be competent to deal with the merits of the Ingeberi Victoria Umhoza case in its May session and with other 5 cases pending before it. I will come back to talk a little bit about that. Some conclusions. There seem to be consensus that whatever the legality of the withdrawal by Rwanda of its declaration under Article 34.6, the effect cannot be excluded from the court's jurisdiction. Any case that has been submitted to the court before the withdrawal has been effective. It therefore seemed quite clear that the main objective of the withdrawal of Rwanda, namely to escape from the court's jurisdiction in respect of the 6 cases pending before the court, cannot be attained. For future cases, assuming that Rwanda's withdrawal is valid, the individuals affected can still submit cases to the Commission, which may, in its discretion, still refer these cases to the court. In other words, by not undoing its ratification of the court's protocol, Rwanda is still accepting the jurisdiction of the court, but only in respect of cases referred to it indirectly by the Commission. In other words, despite the withdrawal of the Article 34.6 declaration, Rwanda still accepts individual access, albeit only indirectly. And so let's break this down. So with this 2-tier system, the first, obviously, with Rwanda signing up to the founding protocol, Article 1, which establishes the core, it allows individuals or anyone or a group of people who have had their human rights violation encroached upon to actually approach the African Court through the African Commission. But as I mentioned earlier, between 2006 and 2020, the African Commission had only referred 3 cases to the African Court, and their communication is not at best. Therefore, they are deemed to be vague, ineffective, and one couldn't actually rely on the Commission for judicial remedy at the regional level. So this was an issue. And this is why the need for that direct access. But what the conclusions that are drawn here are the fact that regardless of the fact that Rwanda has withdrew their Mandate 34.6, which allows direct access by NGOs and individuals to access the African Court, the individuals can still access or have their cases heard through the African Commission's referral to the African Court. And so this is where we are. Thank you once again for watching this channel. Like our videos, share it, add your comments and contributions. If you have any ideas or comments that you think could help understanding these cases and also understanding the position of Rwanda, or if you indeed think Rwanda is a really safe place, then you can actually add those comments. From what I gather here from all these videos that I've made on Rwanda, I am a little bit doubtful that Rwanda is a safe place, that UK refugees should be sent there. Thank you for watching. Until next time, we will bring you the case of Kensarawiwa and the Ogoni people of Nigeria. Thank you for watching.